Oyez, oyez, all persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. The court will hold argument in case number 13-1352, the state of Ohio versus Clark. You may be seated.
Good afternoon. Justice Mikva, Justice Greenberg, and I are very happy to see you all. Ms. McNicholas.
Madam Chief Justice, and may it please the court. My name is Alexandra McNicholas, and I represent the petitioner in this matter, the state of Ohio. May I please reserve 2 minutes for rebuttal?
Of course.
Your Honors, LP is the proven victim of child abuse. He was visibly battered and answered questions his teachers asked him about what happened. Construing this interaction to be more analogous to an ex parte examination, the chief evil of the Sixth Amendment, than a concerned parent talking to their injured child is not rooted in fact, law, or common sense.
Ms. McNicholas, when the teacher first approached LP, she likely did it to figure out if he'd been hurt while under her care. Do you think it matters to our determination of what is testimonial and what is not, what the reason was for her initially approaching the witness?
Yes, Your Honor, because this colors the entire interaction between LP and his two individual teachers. While the supposed testimonial statements were elicited later, that first interaction does provide support for the fact that this was an ongoing emergency. Now, Your Honors, in Davis versus Washington, this court put forward a framework to determine whether and when statements are testimonial. Later, this court in Michigan versus Bryant provided 3 factors to consider in making our analysis.
But let's go back a bit. What about if the purpose of the questioning changes over the course of the interrogation? For example, once that teachers learn that an injury might be the result of abuse rather than an accident.
Yes, Your Honor, that is relevant. And in looking at the primary purpose, if it is to resolve an ongoing emergency, it is non-testimonial. However, if it is to prove past events potentially relevant for later criminal prosecution, it is non-testimonial. Here is the record.
So why should that distinction matter?
Mm-hmm.
Why should we continue to focus on the purpose at the time of the statement rather than the state's purpose in introducing the statement at trial? Isn't that really what the Confrontation Clause is about?
No, Your Honor, because we don't have the benefit of hindsight in our analysis, as this court had said in Michigan versus Bryant. It is what the primary purpose of the interview was at that time. And here's the record shows on 3 and 4A. Ms. Whitley initially approached LP because he was injured. He had a bloodshot and blood-stained eye. Later, in the brighter lights of the classroom, his injuries appeared much more extensive. The lead teacher then asked, "Whoa, what happened? Who did this?" These are informal statements and a knee-jerk response to an injured child. These are not to get testimonial statements to later trial.
And why does the formality versus the informality of the interchange matter?
Your Honors, the formality matters because in an informal environment, this lends support to the fact that there is an ongoing emergency and that the attention of both parties is on that emergency and not to prove past facts.
But weren't the teachers only interested in establishing past events in a domestic violence case? There was no emergency situation here, or was there?
Your Honor, I contend there isn't an ongoing emergency in this case. In Hammond versus Indiana, this court held that when police arrived to the scene of a domestic dispute and separated the perpetrator and restrained him from reapproaching the victim, that the statements then elicited were testimonial because of the formality and because she executed.
Oh, but this is a very different situation, is it not?
Yes, Your Honor. However, we need to use the primary purpose test to evaluate whether and when these statements are testimonial. Continuing with Hammond, in that case, she also executed an affidavit, which this court held in Crawford versus Washington, is expressly what is considered testimonial for purposes of the Confrontation Clause.
But doesn't it matter that these teachers were mandated reporters, that they're state actors, part of whose job is to go to the police or to child protection? Isn't that part of what makes it testimonial here?
No, Your Honor. The mandatory reporting statute they were acting under, Ohio Revised Code 2151.421, required them to report suspected child abuse. However, this did not expressly contemplate them to work with police or cooperate.
Well, the statute, in fact, says one of the people you can report it to is the police. Isn't that right?
Yes, Your Honor. However, the primary purpose of that statute is the protection of children and not the prosecution of those who maltreat them. And
well, we could say that about all police work. It's the protection of the public. Everything is about protecting the public in the end. And part of the way we do that is to prosecute people.
Yes, Your Honor. And child abuse by design does not happen without an abuser, so I'm not suggesting that these are entirely severable purposes. However, we need to consider the primary purpose at this time. The treating physician of LP ranked him on an acuity of 3 out of 5, as the record shows on 71A. He was extremely injured, and his teachers responded to this once they discovered these injuries. This is an ongoing emergency.
You know, it seems like the primary purpose test has generated conflicting conclusions. If you, Ms. McNicholas, were writing on a blank slate and you had to formulate a test to determine whether statements like the one in this case given by a child were testimonial in nature or not, what would your test be?
Your Honor, I would use the primary purpose test. However, in the formality prong of our analysis, I would take into account that these are preschool teachers asking a 3.5-year-old child. They are not law enforcement who brandish a weapon or have a badge. So I would change the test in that way. However,
And why precisely does that matter?
Because, Your Honor, it informs the formality, because when a victim or a witness is talking to the police, they're inherently aware of the stakes of that interaction. Here,
Well, but we're talking about a 3-year-old here.
yes, Your Honor.
You wouldn't want to expect a 3-year-old to have as much respect of, or maybe fear of in some cases, a teacher as a police officer?
Yes, Your Honor, it's possible.
Or what about the social workers in this case? Weren't the statements of the social worker found to be testimonial in this case?
Yes, Your Honor, the statements LP made to the social workers and the detectives were held to be testimonial. However, what was...
Would you have conceded that if you were counsel below?
Yes, Your Honor.
You would have?
Yes, Your Honor, because they were not made to resolve an ongoing emergency. At that point, he was in the custody and control of caring adults. However, up and until their final question to LP, is D big or little, it was unclear whether this abuser was within the classroom or within the school.
Are you suggesting that the only way a statement can be non-testimonial is if it's an emergency? Is that your position?
No, Your Honor. And in Michigan versus Bryant, Justice Sotomayor left that open, that statements may be made not to resolve an ongoing emergency and not to prove past events. And in those cases, those statements would be left to the rules of hearsay of an individual state.
You know, I'd like to go back, if we could, to the objective witness test, because it seems to me that one of the major flaws of that test is that it doesn't address the particularities of young children, of a 3-year-old. You know, young children aren't simply small, less sophisticated adults. They reason differently, they process information differently, they're far more susceptible to suggestion than adults. And we're spending a lot of time, I guess, focusing on what role the teachers played, what role the social workers played. But if we focus on the declarant here, can we really apply the holdings of the cases you've been talking about, Davis and Bryant, to a 3-year-old who hasn't got an idea in the world about what purpose he's answering questions for?
Yes, and Your Honor makes a good point. In Michigan versus Bryant, the third prong we consider is what an objective, reasonable person would consider the primary purpose of the interaction to be. And here, LP is 3.5 and has diminished capacity. So did the victim in Michigan versus Bryant, who was mortally wounded and at a gas station responding to questions from police officers. But this highlights the fact that the objective witness test is insufficient because it narrows our understanding of the events just based on the declarant's perspective. And when a 3.5-year-old is the declarant, this would muddy the waters. This is why we also need to look at Ms. Whitley and Ms. Jones' actions throughout this timeline of events.
So under Bryan, and if I understand correctly, as you're suggesting, we're supposed to consider both the declarant's perspective, or from the declarant's perspective, and from the interrogators, or the government's perspective. What if they point in different directions? What do we do then?
Your Honor, and that is plausible, and that does happen. For example, in Michigan versus Bryant, it's unclear whether the victim appreciated that these questions were being asked to resolve an ongoing emergency and not to prove past events, because they asked who did this, what happened, where did this happen. However, it's a totality of the circumstances test, and we need to look at the different contexts. It's a very fact-specific test, and that's not dispositive whether or not the victim appreciated that they were making testimony. The ultimate inquiry this court held in Michigan versus Bryant is whether these statements were made to resolve an ongoing emergency. And here, as we've stated, LP was significantly injured while in the care, custody, and control of his teachers. They were animated by the fact that they needed to provide a secure environment in their classroom. Moreover, Your Honors, even if they acted to discharge their mandatory reporting duties, they were still not acting to prove past events potentially relevant for later criminal prosecution. As the record shows, at the end of their interaction with LP, they still did not know who D was, in fact. They did not investigate at all.
Where's the emergency? What's the emergency that's going to happen?
Your Honor, the emergency in this circumstance is that LP is at the mercy of an unknown, unreprimanded abuser, and they're not aware if this is in the classroom or outside of it. Once they ascertain that D is big, as the record shows on 21A, they know that this is an adult inflicting this harm on LP. At this point, they made the decision to move down to the supervisor's office to call the 696 number. So the emergency is that they don't know who's doing this, and they're responsible.
So anytime they don't know something, that's an emergency?
No, Your Honor. And in Michigan versus Bryant, this court acknowledged that until the perpetrators apprehended, we're not in a state of ongoing emergency, and petitioner's not suggesting that is the case here. However, up and until they knew D is big, there was an emergency. These were extensive injuries.
Is there any way we could reverse and not find an emergency?
No, Your Honor, because child abuse by design happens in the past. They asked who did this, what happened, because they were his functional first responders in this circumstance.
Well, that seems inconsistent to me with what you said before, because I thought the primary purpose may not be to create testimony, and it may not be an emergency. There could be a third possibility. So it seems to me if that's true, we could reverse without agreeing with you that there's an emergency here.
Yes, Your Honor, I misspoke. There is the possibility that there is another purpose. It could be the security of the classroom. It could be discharging their mandatory reporting duties. But this does not rise to the level of proving past facts potentially relevant for later criminal prosecution.
If LP's statement is deemed non-testimonial, what next? Does it even matter, or will state hearsay rules exclude it anyway?
Your Honor, if this court decides, rightfully so, that his statements are non-testimonial, it would be reversed and remanded to the Supreme Court of Ohio. And then the rules of hearsay would control, in this case, evidence Rule 807, which is a tender years exception, which permits that recent victims of sexual or physical abuse who are of a certain age may talk to people and that it be non-testimonial. For these reasons, Your Honor, I ask this court to reverse the Supreme Court of Ohio. Thank you.
Thank you.
Thank you.
Mr. Smart.
Madam Chief Justice, and may it please the court. My name is Matthew Smart, and I represent the respondent, Darius Clark. A defendant's right to confront the witnesses against him is a foundational right under the Confrontation Clause of the United States Constitution. And as such, this court must revert or affirm the Ohio Supreme Court because the admission of evidence regarding LP's out-of-court statements violated Darius Clark's constitutional rights for one reason. Viewed objectively, the primary purpose of LP's teachers in asking the questions was to prove or establish past facts clearly relevant to criminal prosecution, making LP's statements testimonial and inadmissible.
Well, let me ask you the very same question I started out with Ms. McNicholas, which is when the teacher first approached LP, she likely did it to figure out if he had been hurt while in her class. Do you think it matters to our determination of testimonial what the reason was for her initially approaching?
Your Honor, I think it matters more what happened after that fact. LP arrived at school, as the record shows, roughly after lunchtime. His injuries were first noticed in the cafeteria by Miss Whitley, at which point, as the Chief Justice pointed out, she went up and asked what happened, who did this, at which point LP didn't respond. At which point, the questioning ceased until later in the day when they were removed to the classroom, at which point Miss Whitley went up to LP again and asked exactly the same questions. What happened? Who did this? And the failure of the teacher to take any action at that first questioning certainly points to the indication that there was no ongoing emergency to which that teacher was responding to and asking the
But
question.
wasn't there an ongoing emergency in the sense that the teachers need to figure out whether or not it was safe to send LP home at the end of the day, or whether or not his home was not a safe environment?
Understanding that child abuse is a very serious issue, but the threat of future threat, the threat of sending a child home into a safe environment cannot rise to the level of an ongoing emergency, as this court has stated in Davis.
So is a medical or police emergency the only type of emergency that will suffice to qualify the purpose of questioning as emergent?
Not necessarily, but those are the two examples that this court has seen thus far.
But accepting and I do agree with you that it's not an emergency, I still don't think that the primary purpose is testimonial. There are all sorts of things that teachers have to do besides solve emergencies and create testimony. And it seems to me that they were doing one of them in this case.
In this case, the teachers were acting in accordance to their responsibilities under Ohio Revised Code, the mandatory reporting statute.
Among other things that they were doing, yes.
However, they went above and beyond their responsibilities under that statute.
But the statute only requires a mandated reporter to report the suspected abuse and no more. The reporter doesn't have to determine the cause of the injuries or the perpetrator. All that's left to law enforcement. So doesn't that mean that statements to the mandated reporter are not testimonial?
No, Your Honor. In fact, I think you hit at the heart of the issue at the beginning of your question, where you stated that the teacher's responsibilities ended when they reported suspected child abuse. Here, they went above and beyond that duty by establishing these past facts, by establishing that child abuse did occur and that who the perpetrator of that abuse was. By taking it beyond their reported duty, their mandated duty under the Ohio reporting statute, they began to investigate a crime, which is a job left, as the statute points out in Section A1A, to either Child Protective Services or the police.
Well, what if a neighbor had suspected that and a neighbor had begun to investigate the crime? Would statements made to the neighbor by the child be testimonial?
It, again, is a balancing act under the primary purpose test, and it could that could be a balance that would throw the balance more in favor of being non-testimonial. But here we have two teachers who are agents of law enforcement who at the very...
Stop there. Why are they agents of law enforcement? Why, what basis? I know that's what the Ohio Supreme Court said, but on what basis?
Yeah, Ohio Supreme Court found that mandatory reporters are agents of law enforcement.
All of them, dentists, doctors, they're all agents of law enforcement. Garbage men, I mean, they're not mandated reporters, but they work for the state.
Here they're speaking specifically to the enumerated professionals listed in the Ohio reporting statute, and there they said, when the facts point to an investigatory purpose behind the statements that those teachers in that instance are acting as agents of law enforcement because they have to report those actions, the results of their inquiry to the state, to the police, which will...
Or Child Protective Services, which is who they reported to in this case.
In either case, those statements, those initial inquiries are going to be used to prosecute...
Child Protective Services doesn't prosecute anybody.
Child Protective Services under this statute will then turn the information over to prosecutors. So all information given to Child Protective Services in instances of this mandatory reporting is eligible to be used to prosecute any alleged perpetrator of these acts.
Suppose the teachers had overheard LP telling his little friend that D had beat him up and given him a bloody eye. Would that have been testimonial in your view?
No, Your Honor. And if the teachers reported the abuse at that point, their suspected abuse at that point, those statements would likely be deemed non-testimonial. If the teachers followed up with those questions and investigated, as they did in this case, those past facts establishing exactly what happened, by whom, then the statements would likely be testimonial. Turning to the primary purpose test, which is how this court has laid out, we evaluate whether statements are testimonial or non-testimonial. We see that this court is evaluating three circumstances, three factors rather. And we have already discussed whether or not there was an ongoing emergency, but it's also important to take into consideration the formality of the circumstances surrounding the interrogation and the intentions and statements and actions of the parties involved.
Okay, let's start with formality. Why? I'll ask you the same question I asked counsel petitioner. Why does formality matter, and how does it cut in this case?
Yeah, formality is important because it influences the respondents' intentions in their answers, their understanding of what those answers may be used for. So the formality factor first came out in Crawford, where the court said that statements made while in custody, in police care, after you've been read your Miranda rights, will always be testimonial.
But you do see the contrast between that situation and a child in a classroom or in a...
Absolutely, Your Honor.
I mean, they couldn't be more different.
Formality should actually be viewed on a spectrum. And while the court laid out one end of the spectrum in Crawford, it is yet to lay out the other end, to say that these are circumstances that are so informal as to never...
Well, where on the spectrum does this case lie?
This case lies closer to producing testimonial statements, because what we have here are two agents of law enforcement repeatedly asking the same questions of a witness. They isolate him from the rest of the classroom. And these are circumstances that are very similar to the formality in the circumstances like Crawford. And so here it's sufficiently formal to produce testimonial statements, although it doesn't necessarily rise to the same level of formality that the court laid out in Crawford.
Does a rule that the types of statements at issue in this case are testimonial encourage gaming of the system, such that teachers will begin to always treat suspected child abuse as a medical emergency rather than a situation requiring law enforcement type fact gathering?
It's possible that that could be an outcome, but I would propose that the outcome of this would rather be that teachers will report their suspicion of child abuse at the early possible moment, which would hopefully benefit and root out more cases of child abuse in an effort to end the epidemic that the country.
So you're saying the problem here is the teachers went too far. If they just made that phone call right away, we wouldn't have a problem here. This testimony could come in. Is that what you're saying? It's just that they asked too many questions.
It's that they asked questions at all with the suspicion that there was child abuse, making their...
Wow, would that be better or worse for the administration of justice, in the sense of getting reliable evidence for trial?
But here we're not dealing with reliability. I mean, this court, as it laid out in Crawford, a transition from a reliability test, as it evaluated in Ohio versus Roberts, to whether or not the statements are testimonial. And this court held that determining reliability should be a matter of the cross-examination of one witness being examined during a trial while the other one is present in the court, that is the measure of reliability as to whether or not these statements should come into play.
So if you were writing on a blank slate and you had to formulate a test, what would your test be?
My test would be the primary purpose test, with the one alteration that this court has yet to reach, and that the primary purpose test applies to all inquiries as to whether statements are testimonial or not testimonial, and not necessarily just if the person asking the questions is an agent of law enforcement.
So it kind of doesn't matter under your test whether these people are or not. It's the same as a neighbor. Everybody's the same.
Everybody is subjected to the same test, absolutely.
Then how?
Because we're all agents of law enforcement when we try to solve crimes, in your view.
No, Your Honor, but being an agent of law enforcement certainly speaks to the intention in asking the question and the formality and the circumstances. So if this was a person who is not an agent of law enforcement, it is very well that this test would cut the other way, because the totality of the circumstances, including the formality and the intention in asking and answering the questions, may not rise to the level of testimony, as this court laid out in Crawford.
Well, how do you respond to that parade of horribles in the Ohio Supreme Court's opinion, in which they stated that when when a teacher notices that a child is hungry and asks whether the child had breakfast, the teacher is a police interrogator, because it's possible that the child might disclose reportable neglect.
And in the instance of that hypothetical, the primary purpose in that teacher asking the question is likely one of nurturing and not of establishing a suspicion of child abuse. And so if we view it under the primary purpose test, it's likely to come in as non-testimonial and then be subjected to the state rules of evidence. But here that wasn't the case. And it's also to keep in mind what this case is really about. The petitioner is going to have this court believe that a vote to affirm is a vote in affirmation of child abuse, when in fact that's not the case. Here today what we're dealing with are the foundational rights under the Sixth Amendment. And we need to remember that as we evaluate the case, that LP was protected. That we don't dispute the primary purpose of that reporting statute is to protect children, and that's exactly what happened in this case. LP was removed from a potentially dangerous situation. He was given medical care. And so by all extensive circumstances, we see that that child reporting statute actually worked and that he was protected. And so here, as we deal with this case, what we're really talking about is everyone in this country's fundamental right under the Confrontation Clause of the Sixth Amendment. And to carve out an exception purely because we're dealing in a case of child abuse would violate the very opener that says in every criminal prosecution.
It will have, I'm sorry, go. It will have an impact on child abuse, will it not, child abuse investigations, if you say that every mandated reporter is a police officer. That's essentially what you're saying. By virtue of them being a mandated reporter, they are an agent of the police. And therefore, if they happen to find serious child abuses that should be criminally prosecuted, what they learn, what they hear, can't be used.
What we're saying instead is that under this fact scenario, when a mandated reporter is acting in investigatory capacity, they rise to the level of agent of law enforcement.
Well, of course, a mandated reporter can report child abuse without asking a single question, right?
And in fact, that's what they should have done in this case.
I mean, if a daycare worker notices suspicious injuries, she has to report that suspicion. And without a duty to do any interrogation at all or any duty to investigate, can we really say that teachers become agents of law enforcement?
It's not that their duty to investigate, it's how they acted and the resulting consequences of the use of that information. So because the teachers were investigating these past facts and the information that they obtained is clearly relevant and useful in a criminal prosecution, that elevates them to the level of agent of law enforcement. Without those ramifications, then perhaps they would not be agents of law enforcement.
I assume that, mandated reporters don't receive any training regarding how to properly elicit information from children. Wouldn't that be evidence that the state is not interested in eliciting trial-worthy testimony from mandatory reporters, but rather just in getting whatever information it needs in order to get a child out of harm's way?
I think that's a relevant assessment, but I also think it's important to keep in mind that teachers have developed relationships with kids. Over their entire careers, teachers understand how to speak to children and ask them questions to ascertain answers in a way that police officers likely don't. So a lack of formal training in terms of investigating in the way police would is perhaps irrelevant because teachers are capable of ascertaining that same information. Thank you.
Thank you.
Your Honors, I have one point on rebuttal. Respondent would like to suggest that the abuse LP suffered is non-actionable in our courts because the teachers did too much under their mandatory reporting duties. This is incorrect. They did not investigate. They asked preliminary questions to ascertain whether a threat was in or outside of their classroom. They did not go above and beyond their duties. They merely discharged their duties once they were aware of the fact that D was big. Concluding today that LP was not facing an ongoing emergency is illogical. If we look at domestic victims of abuse, they have the option of leaving, but imagine they didn't, and they left the home in the morning. They couldn't call the police, they couldn't talk to anyone because they were scared, and they returned later that day. This is precisely LP's situation, except it's not learned helplessness, it's actual helplessness.
Counsel, how can the words of a 3-year-old child, a child who was found incompetent to testify in Mr. Clark's trial, how can admitting that through the testimony of another witness be consistent with the purposes of the Confrontation Clause?
Your Honor, his competency was not determined until months after these statements were given, and the trial court...
Well, you're not suggesting, are you, that he became less competent as he... I mean, there's no reason to suspect that he was even more competent when he was even younger, correct?
No, Your Honor. However, when he spoke to his teachers, this was the equivalent of a prompt outcry. They were his functional first responders. For these reasons, Your Honors, I ask this court to reverse the Supreme Court of Ohio. Thank you.
Thanks to both counsel, and the case will be taken under advisement.